Alrighty, got Harrington here. So last week we talked about a real case of mine involving a right of survivorship. And today I want to do another real life case, and it's kind of the opposite. There was no right of survivorship, and both cases ended up being problematic. So I think we got something to learn there, and here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1, just a quick recap. What is this right of survivorship thing, and what was the issue last week? Okay, last week we talked about a mother and daughter who were both on title with that special phrase, that magical phrase, right of survivorship, which is often done, and it can be very efficient. It can be efficient, but turns out it has a nasty, drawback to it. The purpose of doing that is so that if one of the parties on title passes away, then the other party or parties remain on title without having to go through any kind of a probate or any kind of transfer. It just happens automatically. So, that's nice. What is not nice, if you want to go back to the last episode, is that if something goes wrong with the property, as it did with these other clients of mine, it's possible that somebody who's on title maybe doesn't really have anything to do with the property at all, other than just waiting for, to inherit it. They can get hauled into court, and that's what happened. They can find themselves exposed to liability related to the property merely because they're on title with a right of survivorship. Okay, let's make this part 2. I've been noticing that my videos are getting long-winded. Freaking lawyers. Sorry about that. So let's move on to part 2, and I will get back to my 10-minute parameters. All right. What happened in this case? Okay, so we have, the traditional family home, like where the parents or grandparents live. It's the kind of place where everybody goes for Christmas holidays and all that. It's, just grandma and grandpa's house. Well, the parents died, and their property went through probate. So, and what happened was, at the end of it, the judge determined who were the heirs, and there were 3 or 4 children. So the judge put the children on title to the property. Okay, all good. It's unfortunate you had to go through the probate, but that would be the process. So then now we have, let's say, 4 siblings on title to the property, but there is no right of survivorship. I mean, that is a clause that you would have to do on purpose. You would have to elect to do that and ask your attorney to draw up the deed with that little magical phrase. So the judge doesn't do that at the end of the probate. He just puts everybody on title. So there is no right of survivorship. And when you have that situation, multiple people on title, you call it tenants in common. Doesn't matter. The point is, what to keep in mind is that if there's no right of survivorship, then that means whenever one of them passes away, their interest passes to their heirs. Okay, that's where things get interesting. So grandma and grandpa, mom and dad pass away, and now we have all the siblings, the children on title, and then in this case, everybody just kind of forgot about it. I mean, they just kind of lived their lives until they started passing away. And the home was just sort of in the family, for many years. All right. Well, eventually we get to the point where somebody, a grandchild in this case, wants to sell the property. And now we need to figure out who are the parties that need to sign off on that sale. Okay, well, some of those siblings had passed away. Some of the tenants in common that were on title have passed away. If there had been a right of survivorship, then that would make things easier and easier, because every time somebody drops off, then there are fewer people on title, fewer signatures you need in order to close the sale. Just the opposite if you don't have a right of survivorship. Now we have to go chase down the heirs to each and every one of these siblings and try to figure out who they are, if they're children or adults, if they themselves have passed away, and if so, do they have children? You see what I mean? This thing sort of spider webs out. Now, I guess if you are kind of a tight family and everybody sort of sticks around in the same geographical area, maybe it's not the end of the world. You can it's family reunion, right? You can just get everybody together and get the signatures you need. There might be 20 people at this point that have to sign off, but you can make it happen. All right, well, in this real life case of mine, we have family members in other countries, and people have lost touch with those family members. So they have no idea who's alive or what children have been born. They don't have any idea how to find these people. So there you go. I mean, I don't mean to drive you guys crazy, because we talked about, what can go wrong when you have a right of survivorship. And now I'm telling you what can go wrong if you don't have a right of survivorship. but these are real life cases and I'm giving it to you guys straight. All right, then, part 3. So what are we to make of all this? Okay, well, I'll tell you guys, the longer I practice and the more I think about it and the more we go through these situations, the more I love trust. As we discussed last week, the advantage of a trust, if you have that option available to you, is that you don't have to put somebody on title with a right of survivorship and thereby expose them to possible problems that come up in connection with the property. You don't have that issue if you're using a trust. Yet, you can also avoid probate because you just name, the beneficiary, and you don't have to put them on title. Similarly, but not exactly, but similarly, the problem that we ran into with this case, today's case, where the judge put, the brothers and sisters on title as tenants in common, if the property had been put into a trust, we could have avoided a lot of problems that way as well. Now, it is the case that even in a trust, when you name the beneficiaries, you're probably going to want to name the successors in case something happens to the beneficiaries. And in that situation, you're faced with making the same decision. Are you going to have, if one beneficiary passes away, are you going to have that beneficiary's interest be divided among the remaining beneficiaries? That's one option. Or you can have that beneficiary's interest go to their heirs. That's another option. And I suppose if you chose to have all the beneficiaries' interests go to their heirs, then you'd be potentially in a similar situation as my poor client who has no idea how he's ever going to be able to sell this property. But let's face it, if you're taking the time to put together a trust and you're doing it with an attorney, he's going to be asking you these questions, you're going to play out some scenarios, and you're likely to include some special language saying, if a beneficiary disappears, we don't know where they are, and we've made efforts, and, then at that point, that beneficiary's interest gets divided among the remaining beneficiaries, those who can be found. Okay, let's call it there because I want to keep these videos shorter than I have been lately. I do recall saying once, I think back in episode 36, maybe when I was talking about specialty deeds, that these are quick videos, and I'm just giving you enough information to be dangerous, so don't go out there writing your own deeds. And now you know why. Como siempre, recuerda que hablamos español, and I will see you guys soon. You know what to do down there, the honorable thing with the likes and stuff. See you guys.